Welcome, everyone. We're doing a deep dive today into, well, a really complex area, preventive detention and risk assessment. We're working from the source materials you've provided.
That's right. And our mission, if you like, is to unpack the legal arguments, the ethical dimensions, and the history behind these kinds of laws.
It's definitely a sensitive topic, balancing public safety, which is crucial, against individual rights, liberty.
Absolutely. And the sources cover a lot of ground: mental health law, sex offender legislation,
Hmm.
even anti-terrorism measures. We're looking at England, Wales, Scotland, the U.S., Canada, Australia, New Zealand. Quite the scope.
Exactly. So we're not just listing laws. We're trying to get into the core legal thinking, the ethical challenges, and frankly, the difficulty of trying to predict what someone might do in the future.
It's a fundamental challenge for the legal system.
Okay, so where should we start? Maybe with the history. Where does this idea of detaining someone before they commit a crime or based on suspicion come from?
Well, it's not entirely new. The sources point back to 19th century Australia, specifically the Robbers and Housebreakers Act of 1830 in New South Wales.
1830. Wow. What did that allow?
It essentially allowed authorities to apprehend someone based on reasonable suspicion that they were an escaped convict, someone transported and unlawfully at large.
Okay, reasonable suspicion. But the kicker was,
The burden of proof, it was flipped. The apprehended person had to prove to a justice of the peace that they weren't who the authorities suspected them to be.
so prove your innocence, basically, instead of the state proving guilt.
Precisely. And if failure meant potential indefinite detention. It was known as the Bushranging Act, detention without charge based on suspicion.
Right. And you mentioned this context of 19th century Australia, lots of transported convicts, anxieties about crime.
Exactly. You had significant social upheaval, fears about lawlessness, especially outside the main settlements. So this act, however legally dubious, probably felt like a necessary measure to many people at the time, a quick fix for a perceived threat.
But not everyone agreed, legally speaking.
No. Justice William Westbrook Burton, in 1834, strongly condemned it. He argued it was repugnant to English law.
Because of that reversed burden of proof.
Yes, he saw it as undermining the presumption of freedom, a core principle. It went against established ideas of habeas corpus and due process. Logically inconsistent, he thought.
Yet the act kept getting renewed.
It did, for decades. Which just highlights this recurring tension, doesn't it? The push for public safety, especially in fearful times, sometimes overriding fundamental legal principles.
It's a pattern we still see today, arguably.
Absolutely. Which maybe brings us to some of the underlying theories about risk in society.
Hmm.
How do we even think about risk?
The sources mention three main sociological approaches: cultural symbolic, governmentality, and risk society.
Right. The cultural view emphasizes how risk perception isn't universal. It changes depending on your background, where you live. But Ulrich Beck's risk society idea seems especially relevant here.
Beck's theory. That's about modern society creating new kinds of risks, manufactured risks.
Yeah. Risks that are often large-scale, hard to see, maybe stemming from technology or industry. Think climate change, or, relevant here, maybe the perceived threat of global terrorism.
And these kinds of risks make people anxious, demanding more security.
That's the argument. This generalized anxiety pushes governments towards more proactive preventive measures because the potential harm feels so catastrophic, even if it's statistically unlikely for any one individual.
Can we see that playing out in the legal responses mentioned in the sources, like post 9/11?
I think so, yes. The sources discuss anti-terrorism legislation across various countries after 9/11. There was a definite shift towards prevention, expanded surveillance, lower thresholds for detention in some cases, the logic being that traditional reactive justice isn't enough for these kinds of threats.
Which leads nicely into that concept of actuarial justice, Feely and Simon.
Their argument is that modern justice systems increasingly use statistical methods, actuarial tools to manage risk,
So less focus on the individual person, their morals, rehabilitation.
and more on identifying groups based on statistical risk profiles and managing those groups. It's a shift towards managing populations, identifying the dangerous categories.
Like insurance companies assess risk for groups.
Exactly, that kind of logic. Though the sources also note this isn't entirely brand new record-keeping, managing undesirables. These practices have older roots.
And there's the precautionary principle, too. Act before harm, even without certainty.
Yes, particularly when the potential harm seems huge. It justifies curtailing liberty based on probabilities, not just proven facts. Radical prevention, some call it.
Okay, so that's the sociological angle. What about the psychology? Why do we fear certain risks so much?
Social psychology gives us some important clues. Sunstein's work on heuristics is mentioned, the availability heuristic, for instance.
That's about how easily examples come to mind.
Right. If you can easily recall vivid examples like news reports of terrorist attacks or shocking crimes, you tend to overestimate how likely those events are.
Even if statistically they're rare,
Even then. And then there's probability neglect.
where we focus on how bad the outcome could be, not how likely.
Exactly. The emotional impact, the vividness, overrides the rational calculation of probability.
So applied to preventive detention, fear of terrorism, fueled by available images, drives support for tough measures.
Plausibly, yes. And strong emotional reactions to certain crimes, like sexual offenses, can lead to intense public pressure for preventive action against those groups, sometimes overlooking individual assessments.
The sources mention Kemshall and Wood talking about extraordinary cases driving policy.
Yes, those high-profile, very violent incidents often have a disproportionate impact on law and policy, pushing towards more punitive or preventive stances, perhaps more than the data alone would justify.
Okay, so we have the theories, the psychology, let's get practical. What about the actual tools used to assess risk?
This ties back to that actuarial justice idea, the rise of standardized risk assessment instruments. These often rely on static factors,
Static means
things from the past that don't change. Criminal history, age at first offense, that sort of thing. They're used to calculate a statistical probability of future offending.
but how accurate are these predictions? The sources mention the Backstrom case.
Ah, Backstrom, a classic. Back in the 60s, individuals civilly committed in New York after their prison sentences, deemed dangerous, were ordered released by the Supreme Court.
And what happened?
Follow-up studies found that far fewer of them reoffended violently than had been predicted by clinicians. It was a stark demonstration of the tendency to over-predict dangerousness.
So predicting the future is hard, even with scientific-looking tools.
It's incredibly difficult. And while actuarial tools aim for more objectivity than purely clinical judgment, they have their own issues. Hansen, for example, criticized the over-reliance on static factors.
Why? Because they don't account for change.
Precisely. Static factors don't capture if someone has engaged in treatment, changed their lifestyle, gained insight dynamic factors that might actually reduce their risk. Predicting based only on the past assumes people don't change.
And using these scales in court. That must raise problems too.
Huge problems.
Yeah.
How do you apply a group statistic to one specific person sitting in court? Justice Blaxell, in that Mularvey case in WA, pointed this out regarding the Static 99 tool. It doesn't tell you about the current risk factors.
Right, so the translation from group data to individual case is tricky.
Very. And then there's the question of how much weight the court should even give this evidence. It's a major point of debate.
Okay, so let's look at the legal frameworks themselves. How does the law actually define and use this concept of risk or dangerousness?
Well, it varies. In mental health law, dangerousness often became a criterion for civil commitment after cases like Donaldson v. O'Connor in the U.S. But what counts as harm?
Is it just physical harm?
Not always. Some laws specify serious harm. Others, like in Canada, have been interpreted to include psychological, social, or even financial harm. That definitional flexibility is significant.
Then you have specific laws targeting certain groups, like the sexually violent predator laws in the U.S. from the 90s.
Yes, and similar post-sentence detention laws for sex offenders emerged in Australia, starting with Queensland in 2003.
What's the legal argument for holding someone after they've served their sentence?
It often rests on the idea that these individuals have a mental abnormality, making them likely to reoffend, posing an ongoing danger. The state invokes its power to protect the community, the parents patriae doctrine or police powers.
And then terrorism laws post 9/11 brought in different standards again, like reasonable suspicion.
Exactly. That's a much lower bar than, say, proof beyond reasonable doubt for a conviction, or even the standards often used for civil commitment.
Why the lower standard?
The rationale given is usually the potentially catastrophic nature of terrorism and the need to act preventively based on intelligence, even if it's not conclusive proof.
But that raises concerns about potential overreach, doesn't it?
Yeah.
Especially with broad definitions of terrorist act in some laws.
Absolutely. The potential breadth of these definitions, like in the Australian Criminal Code or the U.S. Patriot Act, has been heavily scrutinized. And cases like Thomas v. Mowbray in Australia, challenging preventive detention orders, or the U.S. legal battles over detaining enemy combatants, show these deep legal tensions.
It's not just about detention either. There are supervision orders, control orders.
That's less restrictive measures, supposedly.
Yeah.
Things like post-sentence supervision for sex offenders, maybe with electronic monitoring. In the UK, you had SOPOs, sexual offense prevention orders, and CTOs, community treatment orders for mental illness.
What's the logic there? Managing risk in the community.
Essentially, yes. Imposing conditions, restrictions, maybe mandated treatment to try and prevent harm without resorting to full detention. Still significant infringements on liberty, though.
Okay, a crucial point in all of this must be the standard of proof. How certain does the state need to be about this future risk?
And that's where it gets really messy, legally speaking. The sources show a whole spectrum of standards being used.
Like what?
You've got reasonable suspicion at the low end, often for initial arrest or orders, then maybe reasonable belief, then balance of probabilities, the usual civil standard, then higher standards like high degree of probability, clear and convincing evidence, and sometimes even beyond reasonable doubt, the criminal standard.
Wow, that's a huge range. Is it clear which standard applies when?
Not always. There's significant debate and variation. Look at the New Zealand cases mentioned, McDonnell and McIntosh, arguing over the right standard for extended supervision, or the UK using the criminal standard for civil ASBOs, and the US often requiring it for post-sentence sex offender commitment.
What about Australia's sex offender laws?
They often use a high degree of probability standard.
Yeah.
But how high is high? Cases like Tillman and Winters show the courts grappling with interpretation.
And even reasonable belief or reasonable suspicion. How are those defined?
There are lower thresholds. Reasonable suspicion is often linked to arrest powers, as discussed in cases like Shaban bin Hussein. It requires less certainty than proving something on the balance of probabilities.
And judges have discretion in weighing the evidence.
A lot of discretion. Justice Kirby mentioned common sense reasoning, but Freckleton raised concerns about extra-legal factors potentially influencing decisions, especially in mental health tribunals.
Which brings us to the role of experts, psychiatrists, psychologists in providing evidence about risk.
Yes, their opinions are often central, but their testimony is also subject to rules of evidence and judicial scrutiny.
Are judges just accepting what the experts say?
They're meant to be gatekeepers. They decide if the expert evidence is admissible and how much weight to give it. While risk assessment evidence is generally admitted in places like Australia, as Rashina notes, there's a difference between evidence being admissible and being sufficient to meet the legal standard of proof.
And Barnett and Hayes pointed out the difficulty of finding a consistent standard in these hybrid civil commitment schemes.
Exactly. You're trying to justify a serious loss of liberty, often indefinitely, but maybe not using the full criminal standard. It's a legal gray area. The U.S. Supreme Court in Eddington v. Texas even noted that different stated standards might not lead to vastly different outcomes in practice because of judicial discretion.
Underlying all these legal mechanics are fundamental human rights issues, aren't there?
Absolutely. The core conflict is community protection versus individual liberty. Rights like freedom from arbitrary detention are bedrock principles in international law.
Like in the Universal Declaration of Human Rights, the ICCPR.
Yes, Article 9 of the UDHR and ICCPR, and Article 5 of the European Convention on Human Rights. These instruments guarantee liberty but allow exceptions under lawful procedures.
Have international bodies weighed in on preventive detention?
They have. The UN Human Rights Committee has questioned post-sentence schemes. The European Court of Human Rights has found some systems, like Germany's indefinite preventative detention, to violate Article 5.
What about detention based on mental health?
The ECHR has specific criteria for that, too, cases like Winterwerp and Stanev. You need a reliable diagnosis of a severe disorder, and continued detention must be justified. HLV UK addressed detention of those lacking capacity to consent.
And community treatment orders.
Dawson argues they can be rights compliant if criteria are met focus on mental state, reviews, fairness, proportionality. But Article 14 of the Convention on the Rights of Persons with Disabilities is increasingly used to challenge any detention based on disability itself.
Can rights ever be suspended, like in emergencies?
Article 4 of the ICCPR allows derogation in genuine public emergencies, but not from all rights. Judicial review of detention, for example, is usually non-derogable.
Like the UK post-9/11 situation.
Right. The UK derogated from Article 5. But the House of Lords ultimately ruled in A and others that the threat didn't justify indefinite detention without charge for foreign nationals. The courts pushed back.
And control orders were also challenged.
Yes. The ECHR looked at whether control orders amounted to a deprivation of liberty in JJ and others. And MB and AF emphasized the need for fair hearing procedures, even with national security concerns.
There's also the double jeopardy argument with post-sentence detention. punishing someone twice.
That argument has been raised, notably in the Farden case in Australia.
Mm.
The High Court majority rejected it, framing the laws as protective, not punitive. But it's a recurring concern.
Justice Kirby's dissent in Farden drew a really strong parallel, didn't he?
He did. He drew parallels with Nazi Germany's eugenics laws, warning against laws based on predicted character rather than proven past conduct. A powerful ethical critique.
Speaking of ethics, what about the professionals involved, the psychiatrists and psychologists doing the assessments?
It puts them in a very difficult ethical position. Are they helping the justice system, or are they enabling potentially unjust deprivations of liberty?
Are there clear ethical guidelines?
There are different views. Some say never testify in these contexts. Others say always testify if asked. A middle ground suggests it depends. The ethicality hinges on the specific legal context, the potential consequences, the reliability of the assessment.
What are the main ethical worries?
Concerns about predicting dangerousness categorically, which some argue lacks a solid scientific basis, the indeterminacy of legal terms like risk, forcing clinicians to make what are essentially political or social judgments, and the potential for defensive practice over predicting risk to avoid blame if something goes wrong.
So a duty to detain fear.
Potentially.
Mm-hmm.
Grisso and Applebaum suggest a pragmatic, ethical approach. Testimony isn't inherently unethical, but its use is, depending on how much liberty is restricted and the potential benefits versus harms. Experts need to be competent, aware of limitations, unbiased, and transparent.
Okay, let's quickly touch on those case studies to make this more concrete. Jack Thomas in Australia.
His case involved an interim control order under anti-terrorism laws, based on suspected links to groups like Jamaat Islamiyah and Al-Qaeda.
And the High Court challenge. Thomas v. Mowbray.
The High Court actually upheld the constitutionality of the control order regime itself, which was a landmark decision. But interestingly, the specific control order against Thomas wasn't ultimately confirmed by the authorities. He was later convicted only on a passport charge.
So the law stood, but applying it to him was complex.
It shows the gap between suspicion, intelligence, and the evidence needed even for these preventative measures.
And Robert Farden, the Queensland case.
Farden's case was pivotal for post-sentence preventive detention of sex offenders in Australia. He had a long history of violent sexual offending. An order was sought under Queensland's new act just as he was about to be released.
And the High Court upheld that act too.
Yes, in Farden v. Attorney General QL. That decision really paved the way for similar laws in other Australian states. Farden himself ended up under supervision and eventually an indefinite detention order for care, control, or treatment.
It highlights the potentially lifelong consequences of these laws based on risk prediction.
Absolutely. These aren't abstract legal debates. They have profound, lasting impacts on individuals' lives.
So wrapping this deep dive up, we've covered a lot. History, theory, psychology, law, human rights, ethics, specific cases.
And what stands out is the sheer complexity. There's no easy answer to balancing community safety and individual liberty when dealing with predicted future harm.
We see different countries, even different states, taking inconsistent approaches, especially regarding standards of proof.
Right, and international human rights bodies are clearly watching and often expressing concern about these regimes. The tension is undeniable.
So the debate continues. It really forces us to think about our fundamental values, security versus freedom, the role of the state, how much uncertainty we tolerate when liberty is at stake.
Exactly. It's an ongoing challenge for legal systems and societies everywhere. How do you manage risk justly and ethically? There are no simple formulas.
A lot for you, the listener, to think about there. Reflecting on these arguments, the legal frameworks, the human cost, it really gets to the heart of what we mean by justice in a complex world.